We're talking about the conduct of the commissioners. Now there's an absolute stalemate. Initially, there was the four who dissented and said there was an opaqueness when it comes to the declaration of the final tally. Now the chairperson comes out and says they wanted to force a runoff. So what do you make of the conduct of those commissioners, including the chairperson? And going forward, should we be seeking some sort of unanimity in terms of voice, or should this be allowed to continue? Because then how does it dent the integrity of the poll?
Good morning, Trevor, Prof. Kevin. Apologies, I'm joining you slightly late. Yes, and I agree with Prof. Right now, we are looking at the credibility, verifiability of the results. That is about the numbers. Do we trust the numbers? And it is really maybe the issue about how the IBC engages and conducts itself is a separate issue. And given what the law says, the mandate of the National Returning Officer is vis-a-vis the Commission, there may be some gray areas. And that is why it's important that this process then goes to court. So I would say that it's about the numbers. The result was announced in line with the law. And if you listen to the legal interpretations coming out, they are divided in terms of how the IBC conducts it, how decisions, maybe how the conduct is made, but it's clear who makes the announcement. So those gray areas are the reason we have litigation. And the Supreme Court is going to help us decipher this situation with more clarity. But my expectation is that they will deal with the result in terms of the numbers. Was there due process at the polling station? They will look at the Form 34A. Can we trust that these results reflect the will of the people? Was there due process followed? At the point where this was then transmitted to bombers, we know we waited for some 4 or 5 days as verification took place. And we're expecting, as you verify these results by constituency, you are actually, whatever number comes out, has already been verified. So this looks like the governance style, what is expected. It doesn't look, as Prof has very well said, that it impacted the results. So we expect the evidence brought forward to demonstrate either there were material defects in the voter register, and these material defects then translated into the tally at the constituency, because the national tally is based on the constituency tally, the 34A. So if there is a discrepancy, then we can talk about a material defect. Otherwise, then we are saying, how should Chebukati conduct himself? The last point I want to make is we are operating in a very low trust environment. Unfortunately, we've seen becoming an officer of the IBC in any of the elections is a very hazardous job. We've seen 2 deaths, and those we know are directly linked to the process. People who are trying to circumvent and compromise the process, and when they didn't comply, we saw that they were eliminated by political interests. So we can imagine there was equally pressure on Chebukati. And at some point, and we know this from 2017, we know this from 2013, where the political actors are trying to interfere. So at some point, as the person responsible, you can isolate yourself to make the decision, interrogate yourself, make a decision, and make an announcement. So we are going to see, based on the evidence brought forward, who the actors were, what the forces were, and if this is a genuine issue of concern, or whether it is just more politics, because nobody wants to lose. And they will do everything they can to disparage the situation. So for the 4 IBC officers, they better have some strong evidence. Otherwise, it will be their credibility on the dock. With the, if you recall, in 2007, when we had the Kriegler Commission, again, during the preparation of the report, some of the members of the commission felt they could not endorse some aspects of the report. What did they do? They took part in the process. They did make their announcement, but they were recorded on record that they dissented to some aspects of that report. But they did try and disrupt the entire process, did not try to stop the release of the report, because there is a national good here. There is a process that has been, has an A to Z. So if you don't agree with points X and Y, but you're in agreement with everything else, and X and Y do not undermine the veracity of the report, there is a way to conduct yourself. So I think the 4 may come short in this instance if they do not provide evidence. Of course, if they do, again, the court will be the one to judge.